Now, in the ideal
Okay.
world, we want an entity that's freshly created, so that when an immigration officer is scrutinizing the history of the business, it stops with a recently created business entity, and avoid the potential risk of scrutinizing an entity that was created long ago, especially if, like, after its original creation, there were some transactions or deposit, maybe cash deposits or other commercial transactions utilized for that entity. Well, upon scrutinizing the business entity from its original creation, those transactions, if any, would come under scrutiny, and that could, potentially impact or disrupt the E-2 visa case. So ideally, we want the visa officer to focus on the business for which we're qualifying for the E-2 visa and minimize distractions that are irrelevant to the investment and business at hand. So in the ideal world, as an optimal E-2 visa strategy, I would typically recommend registering a new entity for the E-2 business investment and avoid using a entity that was created long ago, because there might be, things kind of like things that we don't know or don't remember that was transpired for that old entity, that we don't want a distraction to the visa officer's E-2 visa decision and evaluation. But sometimes it's appropriate to use a long ago registered entity for, depending on the applicant's individual circumstances. There are times where it's not feasible or sometimes not possible for the applicant to make another trip to the United States to create an entity, get EIN, and open a new business bank account for the newly registered entity. Thereby, we're kind of forced to use the old entity, which already has a bank account, already has an EIN, and avoid having the applicant making an extra trip just to create another entity and open a new business bank account. So using an old entity could be an appropriate strategy depending on the applicant's personal circumstances.
I'm thinking that my LLC is already open. Since I haven't done anything, there are no transactions, as you had mentioned. I could go ahead and just keep that and not have to open another one, because I don't have time to do that once I get back to the US. Does that sound okay?
Yeah, if time is of the essence, meaning that you don't have the time to register a new entity, get a new EIN, open a new business bank account, if you lack the time to be able to do that, to start fresh, then it may be appropriate to use a previously created entity for which you haven't used it for any purpose. There's no transaction, nothing like that. It should generally be fine. But just as a caveat, depending on what visa status you entered when you create that entity, it may still potentially raise questions. For example, if you previously entered as a pleasure tourist visitor, B2 visitor, and then you created an entity, let's say a year or 2 or 3 years ago, it could still potentially raise question as to why you were here as a tourist and you decided to create a business entity and never end up using it. So there's still that element of a small risk of potential distraction, scrutiny as to the appropriateness of creating a business entity while visiting as a purely pleasure leisure visitor. And what was the intention and purpose of that? Did that contradict your visa status at that time? So, but that's a small risk. And so, you have to kind of balance the pros and cons. If you have no time to create a new entity and there's a time of essence to proceed with a business startup or investment to qualify for the E-2 visa, and registering a new entity would be a huge distraction or detrimental to the new investment, then I'm generally okay with using a previously registered entity that has not been utilized for any purpose and just has simply been inactive all this time.